Troy Wirth, Wirth Financial and Insurance Services. In today's video, we're joined with content expert Craig Redler of the Jeffrey M. Verdon Law Group. And we're going to talk about the private retirement plan, which is a special statute in the state of California for the small business owner. And it has some unique opportunities for the business owner. So with that, here we go. Good morning, Craig.
Thank you very much for asking me to sit down with you.
This personal retirement plan, of course, I think most business owners, a lot of them don't have a pension plan. They're not interested in it unless maybe there is, they're trying to retain key employees or retain employees, or perhaps if they need creditor protection. But maybe you could just kind of frame up what this is. You know, does it fall within the parameters of ERISA like a traditional 401k or pension plan? Where does it fit?
It is not ERISA enabled at all. It is actually a creature of a California statute, and it's open only to California residents. You mentioned using it as a retirement plans for your employees. Typically, my experience with these is the business owners set them up for themselves and only key people. It's not something under the statute that they're required to offer to all their employees. And it's a terrific plan to make sure that you actually have assets when you retire.
So not following the ERISA rules, are you using pre-tax or are we using after-tax dollars to fund this?
After-tax dollars. So it is tax neutral, but what you gain for that tax neutrality is there are no limits on what you can fund into it. There's no set limits for the annually. There is no required minimum distribution at a certain age. There's no requirements that it be offered to other employees in the organization. So you gain a lot of versatility.
Okay. Yeah, because I think it's probably worth noting that, you know, in some ways the conventional wisdom about pension planning is, you know, you got to chase that tax deduction. You got to chase the tax deduction. And maybe for a lot of people, that's a good thing. You get the deduction, you get the deferral, of course, the creditor protection piece of it, but then you're also held to other rules. You can't take the money out prematurely, but for certain definable, you know, hardships. And then you're also forced to take those monies out at what was 70 and a half, now it's 72, or graduating to that. But these are a lot of little pitfalls, I think, that often either a business owner or just people in general don't really understand about the potential challenges associated with traditional pension plan, retirement planning using the sort of the government provided rules.
And I think you touched on a great point. For a lot of people, when they do think of the retirement planning as a tax play, and the California Private Retirement Trust is really not so much a tax play at all. The public policy behind it is just to make sure you have assets when you retire. The state takes the position that it wants people to be able to fund their own retirement, and it doesn't want people to not be able to fund their own retirement because they've gotten sued. So the policy behind this thing is to make sure that money you set aside for your retirement, you don't lose it in a ruinous lawsuit, and that's what our clients use it for. So if you can do other forms of retirement planning, and I certainly wouldn't discourage it, but they can be done in conjunction with the California plan to make sure that when it's time to retire, and by the way, you define your own retirement, when it is and under what circumstances, when it's time to retire, you actually have money to live on. And that's what the people that designed this statute were hoping to deliver to people that utilize it.
Okay. So, and that's a good point. Let's say somebody, I mean, it might be an extreme example, but nevertheless, it's relevant. Somebody's business owners max funded their defined benefit pension. I don't want to use acronyms, DB pension, defined benefit pension plan. They've got a contributory type of a profit sharing, and, you know, maybe there's a 401k piece on it or what have you, but they've already kind of tapped out and they're doing everything that they can on the sort of normal world pension plan side of things. And what you're saying is that these aren't mutually exclusive, that if you're a business owner in the state of California, that you can actually set this plan up in addition to the existing ERISA plan that might already be max funded.
Absolutely. And the other thing the other place it kind of fits in tangentially related to that point is for people that get a late start. If you're 55 or 60 and you really don't have much in an IRA or 401k, and you're starting to think, I'm never going to be able to fund this to a point where I can retire comfortably with one of the California plans, you can front load it heavy. I mean, we would do analytics for you, and if you're underfunded for your retirement and you've got the cash to do it, and you need to put a large sum of money into this thing, we can do it all when we establish it initially up front.
And it really, I guess, just to make the point, it really is driven by the statute. And as you said, I love the word public policy. It's really driven by the idea that the government, in this case, the state of California, feels that a business owner has the ability or the right to try and protect some of their assets because, of course, they have tremendous amount of exposure. For some people, they're in high-risk industries or what have you, and they can end up losing everything through lawsuits, and this is a protection for that.
That's exactly right. That is its basic purpose, to make sure you don't lose everything that you're planning to retire with in a lawsuit.
So even though we could talk about it being a con, pros and cons, it could potentially be construed as being a con that you don't have the tax deduction up front. But in some ways, if it's tax neutral and you're maintaining the integrity of the underlying asset from an estate planning point of view with steps up in basis and certain other things, we can walk down different types of assets. I mean, there may be some substantial advantages to having this type of a plan versus it being construed as a disadvantage.
Well, which is exactly right. And if any client wanted to sit and talk with us about it, we would run through his or her personal situation and make a determination if it's the right plan for them and can illustrate what it can and can't do for them.
Yeah, I think it's, because it almost sounds like, I don't want to say voodoo, but I mean, it just sounds like such a weird animal that I think a lot of people haven't heard of. What types of assets can you put into this? How much versatility do you have in terms of funding vehicles? Because some people own real estate, maybe they have a stock portfolio. I mean, it really covers the gamut.
Virtually anything. That's another brilliant thing about it. There are virtually no limitations. To the extent there's a limitation, it's assets that you're currently consuming. So you're not going to put your personal residence in it. If you're worried about losing your personal residence to a lawsuit, there are other things we can do. You can't use it as your personal piggy bank. You don't want to load it with cash and expect to be able to go down to a bank with an ATM card and take money out of it before you retire. But beyond that, there aren't a ton of limits. It's very, very versatile in terms of being able to put stocks or gold and silver or rental real estate or shares of your own closed corporation, membership in an LLC or shares in a closed corporation, literally anything.
Yeah. And it's interesting too, you talk about public policy. I mean, so you could use an annuity, you could use, obviously real estate would be an obvious one, or life insurance. I mean, there's significant public policy aspects of access to cash value, first in, first out cash value access, and things of that nature.
Yeah, cash value life insurance policy is a real common asset that we put in these things.
Yeah. Well, you talk about tax neutrality because it grows tax deferred. So that's a substantial bonus that you're not actually creating taxability along the continuum, but you're basically protecting the asset and creating a legacy through the insurance, which is kind of putting the retirement plan on steroids because it essentially allows you to fulfill it if you're not there to fund it.
That's exactly right, and you're getting some tax advantages as well when that's where you go.
Yeah. So maybe we could talk for a minute about like how could you integrate this into the context of estate planning? I mean, we talk about retirement planning. That's sort of a living benefit, assuming you live. You're accumulating wealth. You're protecting it from creditors so that you have access to that money so that you can, pay the bills, keep the lights on, and live in retirement. But what about from the perspective of wealth transfer? How would this? Are there creative ways that aren't too far outside the box where this kind of ties into some estate planning, either basic or advanced?
Yeah, sure. No, it's anything that you fund into one of these things is going to pass probate free. You can name beneficiaries, so to the extent that there are still assets left in it when you pass away, you can name your kids or whoever you want as a beneficiary. So it certainly will serve the purpose of offering some basic estate planning, without a doubt.
So because it is a retirement plan, it does have, obviously, to the extent you have named beneficiaries, which you need to make sure that you do that, but it is not probatable because of that.
Correct, 100%.
Yeah, that's fascinating. I mean, that is really a powerful tool. There's got to be some type of administration that you're dealing with.
There is.
So talk a little bit about that, because sometimes that's where there's the hair on the dog. People get into the weeds on those things. But how would that work? What do you need to do to establish the plan? How easy is it to maintain? Is there a process to keep the thing maintained so that it's in good stead and doesn't fall afoul of the rules.
There is, and actually you've got two players in this in addition to the plan participant, which will be our client. You need a trust and you need a plan itself. So the plan itself is a set out in a document that our firm will produce for your company or employer. It should be employee sponsored, although there is no obligation on the part of the employee. That is to say, the employer doesn't have to contribute. But the employer does need to lend its name. So you're going to set up a plan under your employer. And then each participating employee is going to need his or her own trust. So we would set up a separate trust. So with the plan, like an IRA or 401k, it needs a third-party administrator. And there are service providers here in California that offer those services. We use a company up in San Francisco typically. So you have the third-party administrator. They charge a yearly fee. And then you're going to need an independent trustee for the trust itself. Well, it's not necessary to get a professional trustee. We typically recommend that. So you're going to want to get a trust company involved. We usually work with a firm in Nevada. The Nevada trust companies are very good because it's such a powerful trust state. The trust laws there are very good. So by the time you pay your third-party administrator and your trustee, probably looking at about another $4,000, $4,500 a year to maintain it. But it's the best insurance you can buy for that money, for sure.
Yeah. And as you said before, I didn't really touch on it that much, but because it is non-ERISA, because you're using after-tax dollars, you have a lot more flexibility in the selection of key employees or who you would include in participation of the plan. Is that right? Can you talk a little bit about that?
Absolutely, positively. If the business owner just wants to set up one of these trusts for his or herself, that's an option. Just the owner and spouse, we can usually do that. Just the owner and key employees, we can do that. So quite literally, you can be as flexible with that as you want.
Yeah, well, it's really an interesting thing. When, by the way, I'm just curious to know, when was this thing legislated, roughly? I'm not, not to cite chapter and verse.
It's actually a great question because a lot of people are it sounds like some kind of gimmick. It's not. It's been around for close to 50 years. It predates ERISA, actually. Don't quote me on this, but it was right around 1972 or thereabouts. So it's coming up on a 50-year-old statute. So despite the fact that all the wonderful benefits this thing offers, it is tried and true and battle tested. So they absolutely will protect assets that you set aside for retirement.
Yeah, well, I think it's important to note that for especially for our listeners, and there have been things that are form over function and trying to with sleight of hand and things of that nature. But this is not, I mean, as you say, it's statutory, it's black and white, the ink is dry, it's been tested. I'm sure there's probably case law and challenge and et cetera, and it holds water.
Holds water, and there's a lot of cases out there on it, to be sure.
Yeah. Again, as long as you maintain the documentation and all of the basic compliance issues that go along with this type of a plan.
And that's why you want to get the third-party administrator, someone who knows how to administrate one of these plans, because to the extent they do fail, and if you go to the case laws, our case law, there'll be examples of where they failed, but where they failed, it's because they weren't administered properly. Mm-hmm. As an attorney that sets these things up for clients, I can look at any case where one failed and tell you right away, well, here's what they did wrong, and rest assured we don't repeat those mistakes. Yeah.
It's like driving on the freeway. You got a line on this side and a line on that side, and you drive it down the middle, and it's not an issue. It's when you're all over the place it becomes an issue.
Absolutely.
Well, I appreciate you coming on today and sharing this the information on this. And if folks want to get in contact with you, we'll have your information there. What other types of planning do you do at the firm?
Our law firm actually specializes in asset protection almost exclusively. We are, at the end of the day, estate planners and tax attorneys. But we're one of the few firms, and I can say this with confidence, certainly in the Orange County area, LA, and in America for that matter, that emphasizes asset protection the way we do. That is to say, as wonderful as the private retirement trust is, and it is, there are going to be people that can't use it. There are going to be people that it can protect a portion of their estate, but then they have this other portion that it can't protect. And generally, when we do a plan for a client, we are looking to protect them from creditors, no matter from what direction they come. I mentioned earlier, like on private retirement trust, you can't put assets in it that you're currently consuming. You know, we have other techniques for protecting virtually anything in your portfolio.
Yeah. Well, so yeah, and I guess in the context of this can be just a module that's a plug and play. If somebody's already got an estate plan and so forth that's already in play, but they haven't seen this and they come to you for that, it can just be a module that gets plugged in. But I get the sense that it's that the capabilities that you have, that it would potentially be something to review existing planning and look and see where there are maybe some other opportunities that haven't been explored by the client and their advisors.
Couldn't have said it better myself. A lot of people, and I hate seeing this, and they set up an estate plan and they think, well, I'm okay from an asset protection point of view. You're probably not.
Yeah, and I think there's just so much confusion around it anyway. Even just, I mean, high net worth and smart people get a trust and think they do have some modicum of creditor protection, and obviously that's not the case. So
that's why we get up in the morning.
Yeah, no, it's good stuff. Well, I look forward to. We'll next time, I think we should probably discuss going beyond basic estate planning and maybe talk about some other techniques that can be used to protect assets, but also have some access to them.
Be my pleasure.
All right. Well, thanks for being here today, Craig. Appreciate it. And until next time, peace. Be safe.